We're joined now by Senior Advocate of Nigeria, Okutepa. Thank you very much for joining us.
It's nice to see you. Happy New Year.
Same to you. Good to see you, sir.
Thank you.
So this Osun situation is looking like a basket case that refuses to, go away. And when you look at it, the rule of law is the first casualty, whichever side, you belong. But there is the issue of whether, it was proper for the governor, Appellate, to go ahead with the election, considering the local government election, considering the fact that the tenure of the reinstated, in parentheses, the reinstated, local government chairman was yet to lapse.
Well, when you use the word reinstated local government chairman of the 30th local government of Osun State, I'm wondering where you drive your authority for that proposition.
Were they not reinstated by the appeal court?
No court. I've taken my time to read the judgment of the Court of Appeal. There are two, for us to understand this matter, please, there is a need to look at the historical context. Sometimes in 2022, two political parties, PDP and APP, went to court to challenge the arrangements for the local government election. There were two separate suits. PDP case was filed before the promulgation of Osun State local government election law of 2022. In both of these cases, the Federal High Court decided and held that the procedure leading to the election conducted by the then government of Governor Gbenga Oyetola was flawed. He declared the election null and void and of no consequences, and removed the persons who were purported to have been elected through that flawed election. Indeed, the case was pending in court when the said election was conducted. And under the disciplinary power of the court saw that that conduct was an affront to the rule of law, the processes pending before the court, and so in both two cases, the court nullified and ordered that those who were purported elected vacate the office. Now, there were appeals. One appeal by APC, another appeal by APM against the two sets of judgments. Now, in the first case involving APC versus PDP, right, the Court of Appeal looked at the entirety of the case. There were 4 issues for determination formulated in that case. The Court of Appeal resolved issue 1 and 2 and said that the amendment granted by the Federal High Court when the case was pending was wrong. 2, the second order made by the Court of Appeal in that process was that the case itself was premature and that there was no cause of action, and consequently resolved that issue 3 and 4 became academic, and so consequently the Court of Appeal came to a conclusion that the trial court lacked jurisdiction to have entertained the matter in the first place, and then struck out that case that was filed by PDP and made no order. In the 53-page judgment that I have read, there is nowhere an order was made by the Court of Appeal. And it is important for us as lawyers, as general public, not to read into the judgments what is not there contained. There was no prayer in that before the Court of Appeal by any person for reinstatement. And even if there were, prayer 3 and 4 was described by the Court of Appeal as academic, and they ought not to go into it. Fast forwarded, there is also another appeal, because know that there are 2 judgments. There were 2 judgments delivered by and 2 separate judgments in which there were nullification, and declaration that the purported election was null and void. This time around, the second case was the case that APM, one other persons, and APC were the appellant. Now, when they filed the appeal, they went to sleep, did not compile records of appeal, did not file briefs of argument. Then those who were respondents in the appeal now brought a motion before the Court of Appeal because equity aid the vigilant, not the indolent. Right. There are procedure under the court that once you file appeal, you compile a record of appeal within a certain number of days and filed your brief of argument within a certain number of days, and that your failure to do so, the consequences of that failure is a dismissal of the appeal. And so the Court of Appeal in the second appeal dismissed the appeal filed by those who were aggrieved by the decision of the Federal High Court that nullified and set aside the election, which means in law that the judgment of the Federal High Court, which was appealed against, but which appeal was not pursued, right, and which appeal had now been dismissed, remained the judgment of the court. And so there is no, therefore, any order in any of the judgments that those who were dismissed or removed or the election declared null and void by the Federal High Court in the second case that was filed later in time had been ordered to be restored. So when anybody therefore comes to say that there is a disobedience to court order, I wonder which court order. My view, with profound respect, is this: politicians will do well by learning to abide by the consequences of their action. I say this.
Politicians on all sides.
On all sides.
Right.
And you know that I've always said that in any society where the rule of law is bastardized, disdained, looked upon with such contempt and oblique, then you are likely to face what is called state of nature, where the mighty becomes right. Okay. So my view, profoundly, therefore, is that rather than going public to insinuate what is not contained in the judgment and giving political coloration and interpretation to it to suit our political purpose, they should go back to the processes, go back to the proceeding, and then advise themselves. But let me tell you, it does not lie in the mouth of anybody, including myself, to say that the judgment of the Federal High Court, which had been by implication of dismissal of the appeal, be affirmed by the Court of Appeal, because the Court of Appeal had not pronounced whether or not that later judgment was null and void, remain the judgments. And no one can wake up to say that it cannot respect it, because a null and void judgment, until set aside, remain the judgment of courts.
Great. You've taken a great deal of length to explain the matters, and we do appreciate that. But senior advocate, let me ask you, because if senior legal minds cannot agree on this subject matter, we've had two senior advocates sit right in that same chair, one yesterday, one last week, and you all don't seem to agree on the subject matter. Then where is the hope for ordinary Nigerians trying to understand what is lawful and what is not? Is this not a doing of the judiciary, your colleagues?
No. Let me say this. We must make a distinction between when we appear here to say something and look at the background, and whether or not what we are saying can be defended from what is before the court. There is a political interpretation and there is an unbiased legal interpretation. What I have given to you, and it's a challenge, and I challenge any lawyer to come here and point to me where in the Court of Appeal judgments, the two that I have said, that anybody was ordered to be reinstated, the inference I gave for the subsequent dismissal of the case means that nothing had touched the second judgment of the Federal High Court. as to whether or not the Federal High Court has jurisdiction to do the matter is not an argument that I can profile here, because the law that I know is that whoever knows that an order of court against him or her is null and void and of no effect has a duty and responsibility to return to that court and ask that that order be set aside until it is set aside. And I think it was my Lord Honorable Justice Esho that said that when Lord Denny said that an order of court is null and void, does not require anybody to go back to set it aside, it's automatically void. He said no. If you carry that principles of law far, it means that anybody can just sit under the comfort of his room and say an order of court is null and void, and then he will not obey it. So my suggestion to us, therefore, is that before you even invite us here, it's not out of place for you to pick a copy of the judgment to read. And I can oblige you.
There are several judgments.
No. There are no several judgments.
There's a federal high court judgment. There's an appeal court judgment. And there's a state high court that has ordered
there is an order,
and the other appeal court judgment proceeding that has now been enlisted to be revived.
Now, why do they file two separate suits?
You should ask the politicians.
So that is why I say Nigerian politicians must learn how to obey the rules of the game.
Yeah, but it looks like the judiciary itself
is aiding
not
them.
help. Yeah, you know.
No, I do not. I do not agree with you. I do not agree with you.
That's what it looks like.
The judiciary has determined the case. The Federal High Court determined the two suits, nullified the election, said you committed.
Would it be fair to say that politicians just cherry pick? In this case, in the case of Osun, the state government decided that it would go with the ruling or judgment of the High Court.
With profound respect,
that
I'm not from
allowed it to go ahead with
I'm
the
not
election.
from Osun. With profound respect, it would be uncharitable to say the Osun state government choose and pick which to follow. Because if there was any order to even follow, there was an order, from what I read, from the State High Court commanding the Osun State Independent Electoral Commission to go on and conduct the election. For me, that judgment is in line with the decisions of the Supreme Court that at any particular time, the local government must be democratically run.
And not caretaker.
And not caretaker. So I do not see how the judgment that commands obedience to constitutional provision can be described as choose and pick. Well,
apparently we've not seen the end or heard the end of this particular Osun local government election saga. Okutepa,
you know that
we have to say thank you very much.
That is where you have your raw material to feed Nigeria.
Absolutely. Thank you so much. We do appreciate your presence joining us on Newsnight tonight.